One very important circumstance which this note of the Home Secretary indicates is that, as we found from the joint communique which was issued in February 8, 1972, Bangladesh assumed unconditional responsibility to take back those who had come into India after 25th March 1971. Implicitly meaning, therefore, that people who had come into India prior to 25 March 1971, there was no question of deporting these people because Bangladesh would not be willing to take them back. If they were not conferred citizenship, they would be rendered stateless because they would not be going back to Bangladesh. And therefore, it was in that sense a solemn obligation which was undertaken by India in terms of an understanding with Bangladesh that pre 25 March 2071 would remain. And then we must also read it in the context of entry 10 of list 1, which says foreign affairs, all matters which bring the union into relationship with a foreign country.
Correct.
And therefore, the power under Article 72, the executive power would also extend to entry 10. So in that sense, an international understanding between the then Prime Minister of India and the Prime Minister of Bangladesh that they would take back post 25 March 1971. Now, what would you do? These were not illegal, they couldn't be pushed out of Indian territory as illegal immigrants.
So extend the time and give them more time to get
themselves registered. Therefore, the tacit understanding was that they would remain in India. You couldn't push them out back to Bangladesh because that was not the obligation which was assumed by Bangladesh. Therefore, instead of maintaining them as stateless persons in India, at least bring them into the mainstream by conferring the citizenship on them.
Just, as a proposition of law doesn't arise here. Doesn't arise here, So, the political solution, of a problem. Sometimes executive, is confronted with some problem which needs to be resolved by using legislative means. There was that, all right, your argument that from 51 onwards, everyone should not get citizenship. You come down to 66, which they agree. And from 66, the contention was that this large number of influx, and when I show the figures, the time at which the figures are shown, the population of Assam was, say, 1 crore, and the influx was 10 lakhs. So 10% influx changes right of political participation and right of political decision making, right of jobs. All of them didn't, after 71 at least, nobody came because of any war situation there. Up to 71, it can be understood. Because of economic beneficial position in this part of India, in India, the land holdings were very wide, very huge land holdings. The population density was very less. The job opportunities were less. So they came for economic reasons.
They have challenged both subsection 2 and subsection 3, right?
Yes.
They are challenging the entirety. The arguments seem to have been more focused on 3 by Mr. Diwan.
Yes.
But the challenge is the entirety.
They have challenged both. But I'm just justifying this was possibly because what transpired in the meeting between the Prime Minister and the ASU leaders, because I have read the Honorable Prime Minister traveled to Assam and held meetings. So this appears to be, a via media which is found out, that you don't insist on 51. You come down to 66. Then 66 onwards, we will restrict it up to 71 because 6A says whoever comes after 71 would be an illegal immigrant. No benefit, no nothing. Only foreigners tribunal would decide and you will be deported. But their contention that they are changing the political scenario, political representation, etc. Therefore, this via media was found that for 10 years, namely till the decision of foreigners tribunal is taken, you will not have a right of participating in the election. And that right came only after 10 years of the declaration.
What is the date of the surrender of the Pakistani army actually when Lieutenant General Niazi?
16th December 1971. General Niazi and
Arora on our side.
And Jagjit Singh Arora on our side, and one Mr. General Jacob, yes, my lord, he was also instrumental.
He was Major General.
Yes. No, Major General was my lord Jagjit Singh Arora,
That's right.
but Mr. Jacob was, I think, my lord, he was, I'm sorry, I stand corrected.
Lieutenant General Jagdeep Singh Arora, and if I'm not mistaken, Major General Jacob. Jacob was a Major General.
Jacob, my lord, he was, Jagjit Singh Arora was General Officer in Command of Eastern Command. GOC in command, as they say.
So interestingly, I mean, it may or may not have any bearing on constitutional validity. The cutoff date which is chosen, 25th March 1971, excludes all those who came in during that period of flux in Bangladesh, because the cutoff date is not 16 December 1971, it's 25 March 1971. So anybody who came in, that's right, that's what he just said. But therefore, anybody who came in after Operation Searchlight has been excluded from the benefit of such citizenship.
Yes.
So the Bangladeshi influx which took place as a result of the genocide in Bangladesh, they have been excluded by
Because the Prime Minister of Bangladesh
This was
said
the
that we will
compromise.
take them
They
back.
had a cutoff of 25th March 1970.
Because the Honorable Prime Minister of Bangladesh, my lord, said that we'll take everyone who came after 25th March 71
Back into our country.
back into our country. The rest, my lord, 6 and 7, I'll just orally say, somebody can say that I don't want to get benefit of this. My lord, that's all. No, nobody is questioning 6 and 7. And Lord, it is very clear, Lord, from the section that after 71, all are illegal immigrants subject to being so declared by the.
Now we've got the statutory scheme. Now we can go straight to their arguments and address the
yes.
submission.
Yes, my lord. Lord, if your lordships, my lord, there was a question, my lord, about Rule 19.
Yes.
That which came into force in 2013. My lord, I wanted to answer that question so that I can complete the chronology.
Yes.
My lord, your lordships have seen that 6A will be operated as per the rules framed under section 18, my lords. Because, my lord, the first impression of everyone was that what happened till 2013. Even the rules are 2009. So there was no vacuum. My lord, that's all I wanted to say. My lord, nothing may possibly turn on that. But just to complete the history, my lord, and the chronology, my lord, section 6A says that this process will be done as per the rules made under 18EE, small e. That is, my lord, confined to 6A. 18EE, my lord, if your lordships can see. It says 18, but EE, my lord, is I have found, my lord. It's not entire 18, but 18EE was also, my lord, amended.
And that came in by the same amending act.
But yes. Now, immediately thereafter, citizenship rules were framed in 1956, were amended, I'm sorry. Citizenship rules were already in existence since 1956, but they were amended to bring it in conformity with newly inserted section 6A. If your lordships would like to have the date, they were amended on 15th of January 1987 to give effect to, my lord, section 6A. That your lordships would find, these are the rules of 56 amended in 87 to deal with 6A situation.
15D आया था.
Where in case of a person seeking registration under subsection 3 of section 6A, any Lord, I may not read, but there is a reference provision because nothing turns on that. Then 16E is jurisdiction of the tribunal, which says that it would decide the reference under subsection 3 of section 6A. Last line, my lord, of registering authority for the purpose of section 6A3 and form of application for registration. Now, please come to 2, sub-rule 2. An application for registration under subsection 3 of section 6A of the Act shall be filed in Form 23 by the person with the registering authority for the district in which he is ordinarily resident within 30 days from the date of his detection as a foreigner, where such detection takes place after commencement of the rules, or within 30 days of the appointment of registering authority for the district concerned, where such detection has taken place before the commencement of the rules 1986. My lord, there was a time limit prescribed for registration. If I am declared a foreigner and therefore entitled to the benefit of 6A, I'll have to get it registered within 30 days. My lord, the government, from the file, my lord, it appears, and I have, my lord, those documents also, that there were concerns that it is not possible to do it within 30 days. So though we are declared, we have a order of the tribunal, we are unable to get ourselves registered.
So therefore, then they brought in the 2013 amendment to rule 19 and said now 30 days after we issue this notification of these.
That's the reason, my lord. Just to complete, this is, my lord, the note of the then Home Secretary giving the justification for amendment in 2013. Nothing, my lord, may turn on that, my lord, but just to complete.
See, now we get some data. It is pointed out that on July 2012.
I read,
Right, okay.
It is pointed out that as on July 2012, 32,537 number of persons were declared illegal immigrants pertaining to 6671. No, there are other data also in my affidavit. I'll show, my lord. Streamed by the Foreigners Tribunal. Of this, 12,914 number of persons have registered themselves with the registering authority. The remaining persons could not register with the registering authority due to variety of reasons, including expiration of limit of period of 30 days for registration. As a result, a number of cases have been filed before the Guwahati High Court indicating reasons as to how they could not register with the registering authority and praying that limit of the days for registration be relaxed. It would be difficult to repatriate or deport these category of persons to Bangladesh in view of the understanding between the two countries that persons who came to India up to 24th March 71 would not be repatriated to Bangladesh. Eventually, these persons will become stateless persons if they are not allowed to register with the registering authorities. This is a genuine difficulty being faced not only by the state government but also by the identified persons. In view of the above stated positions, it is proposed that rules may be relaxed as suggested in para 5 of the notes on page 1920. N is note section. Your Lordship knows, my lord. So and so. So, my lord, this is how, my lord, the amendment came. First, my lord, 2009 rules came and thereafter they were amended in 2013.